real shenanigans at every corner. Sarcasm, my holy sermon in style. Dark chocolate, melted chaos warmer. Fighting this timeline with snark. Every soul welcome, but no recorders. Baptized by laughter in the dark. We stand tall, scorning fake orders. In the church of glory rise, with chaos and shenanigans bright. Chocolate and sarcasm uprise. Together we light up the night.
Hey guys, it is Mo, and we are here for, oh my goodness, Sarah Boone. So this is the current, this is not the hands-free trial or day. We will probably go over that on Thursday along with her prison notes, but let's get into this hearing. I do have closed captions on. I am boosting the sound as we speak, but I finally been on time for something this year. I believe we should all mark this on our calendars. So let's get to it. They must not have put on the speaker yet.
Oh. Sir, hang on 1 second. I'm waiting for the state. Thank you for your patience.
Wait, the weird time when Sarah Boone's lawyer's chomping at the bit, like, I am here on time and early to get a continuance. Which, granted, if I was Sarah Boone's ninth lawyer, I would want a continuance too.
Thanks.
I must say, I love his eyebrows. He has the best Angry Bird eyebrows. Oh, all right. Awesome. I was wondering why. See if we're. God bless you, Florida. Nothing like keeping time, on a schedule. That would just be, terribly wrong for everyone. Come on. Oh, it's herself, the queen it is. Oh God, she's smiling. I like it better when she's got resting bee face. That smile. Also, Sarah, how the hell do you get a sunburn? Do they have you outside pulling weeds? I'm asking for a friend. It makes me happy to think that, but how did Sarah get a sunburn? I am immediately suspicious of anything that makes her giggle like a schoolgirl, because I know it was someone's pain is involved. I mean, you guys, am I tripping? Does it look like she has a sunburn? And I'm a person that has rosacea at times, so I am not trying to hate on her, but it legitimately looks like she was on the center of the sun.
Sir, good morning, pleasure. Ms. Boone, good morning. Could you please state your, raise your right hand now, first, going to go ahead and swear you in.
Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Ma'am, good morning. Could you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
Good morning, everyone. We are here on several different items. The first is the court's notice of hearing that was sent out last week. The first issue on that was addressing the viewing of the physical evidence here in open court on August 5.
Why am I not
entered an order setting forth certain deadlines and scheduling, including the viewing of the digital evidence no later than September 3, and the physical evidence viewing to take place here in open court on September the 3rd, and a schedule for objections thereafter. The digital evidence review took place on August 9th, and the August 23rd deadline for objections has since passed. On August 14th, the court was advised of an alternative arrangement and advised the state to file a notice reflecting when and where and how that review would have taken place. I did not receive or see such a notice in the court file. Mr. Cashore?
Yes, Your Honor. We were not able to file the notice prior to today. However, on Friday, August the 30th, we were able to have that evidence review of the physical items with Ms. Boone at the Orange County Jail.
Okay, all right. Ms. Boone, can you confirm if in fact that viewing took place?
It took place.
Okay, all right, very good. And who did it take place between the state, yourself, and was Mr. Lane with Prison Break Investigations a part of that viewing?
Correct.
Okay, all right, thank you very much. Also set for hearing this morning was defendant's motion for payment of costs and appointing neuropsychologist to assist the defendant in preparation of the defense that was filed on 14th. The next day, August 15th, JSCS filed a response to the motions for payment of costs and appointment of a neuropsychiatrist. Paragraph 10 of the JSC's response reflects that the JSC will not be participating in this hearing. Mr. Owens, good morning. What is your position, sir, with regard to Ms. Boone's pro se motion for costs? Are you adopting that motion?
I'd like to abandon that one, but substitute it in for two other motions for the appointment of a forensic psychologist, Dr. Julie Harper, who was on this case previously. I believe she saw Sarah Boone about 6 times at the Orange County Jail. She was working under the direction of the original counsel, Mr. Padilla, who I believe had the case for about 2.5 years. And I think it was set for trial, ready to go, and then at the last minute he withdrew. I tried to call him a couple of times, haven't been able to find out what went on.
Withdrew for unforeseeable circumstances. It was like Lemony Snicket was on his ass. No, he withdrew because Sarah is a pain in the ass to deal with. Sir, like, I am all confusion. Why did he quit?
I have talked to Ms. Cashman, the last lawyer, but we don't need this neuropsychologist that Ms. Boone had requested, but we do need a reappointment of the forensic psychologist, Dr. Julie Harper. I've spoken with her a couple of times last week. I text messaged her 4 or 5 times this weekend. She is in agreement to handle the case, to reopen her file. She has sent me her records. I have reviewed them. I've met with my client. I think my client meets the criteria for that spouse. I believe Dr. Harper, after she gets a chance to re-engage with my client, spend some time with my client, and hopes that she's going to be of that opinion. In addition, I believe it's necessary for the appointment of a crime scene reconstructionist and death investigator, Dr. Michael Berkland, who is from my area, Pensacola, is who I am recommending to be appointed.
What was his name again, sir? I'm sorry.
Michael Berkland. I filed these judges yesterday or last night. I don't know if they're in the court file yet.
I did not see them this morning. I did see the motion to dismiss.
Can I push them in?
Yes. State, have you seen them?
I just saw them briefly this morning.
So it is interesting that this lawyer is coming in and does seem to have a general strategy in which, he is asking for another crime scene reconstructionist and a, medical examiner to dispute the cases that were brought, or at least the assertions that were brought by the state's, autopsy. But what I genuinely disagree with, and I hope that the judge stands firm on letting this trial finally go to, this trial finally go to trial, because George's family has waited just as long as Sarah. For every day that Sarah has waited, um, we probably should raise a white flag if you feel threatened at any time. Um, so yeah, we are. I do hope that he does not give her any more continuances. I understand that she has had, incongruency and breaks in lawyer, you know, in lawyers' care, but I am done giving Sarah 90 gajillion chances to act like a functional human, and I would really hope that he sticks with his giving George his justice, getting this case moved through, because it is appalling how long this case has taken.
Prior to the,
Morning, sir.
prior to the hearing.
And good
Thank you.
morning, lawyer's daughter.
The only thing I saw in the court file, Counselor, when I was prepping last night was the motion for statement of particulars, the columns number 2. I have not yet seen these motions.
Judge, I also filed a motion for additional discovery. I don't know if that made it through as well.
Was that also filed yesterday, sir, sometime in the evening?
It was filed at 8:30 yesterday morning.
This lawyer currently suffers from Mo's inability to file anything and or upload things. It's not this lawyer's fault. He was there when the first MacBook was created.
So I have your motion for statement of particulars filed 8:10 yesterday, but I do not have the motion for additional discovery filed 8:34.
I don't know why the court was not able to post that, because they were filed one right after the other.
One's in the court file, the other 3 aren't.
This is what it is.
They were all filed yesterday, 19.
No, certain things auto-populate and certain things have to be accepted.
Okay.
The statement of particulars and the additional discovery were filed yesterday morning. The motion to appoint the crime scene reconstructionist and death investigator, and the motion to appoint the forensic psychologist was filed at 6:10 p.m.
I do see that. As the court previously identified, JCS chose not to participate in this morning's hearing by virtue of their response filed on August 15th.
Sadly, probably.
They're not here. Your motions for these various experts report that they were sent to all persons on service lists through the e-portal. But I don't know how I can address these this morning without having JCS here. So I will endeavor to coordinate a hearing for these as soon as practical. I understand these need to be addressed. Be advised, this is a trial week for the court, as is next week, but I will do my best to endeavor to try to get these heard as soon as possible.
Judge, and I filed my notice of appearance on Friday,
Yes, sir.
and I've spoken with Dr. Berklin 2 or
Now,
3 times this week.
Anyone in the chat, do we have a background on this particular lawyer? Do we know what his general motivation was? Has he spoken or given any public statements as to why he took on Sarah Boone's case? And I am a little curious if he has laid that out, because it is interesting that one would volunteer basically pro bono at this point. Oh, he saw her ad. Have we done a psych test on this lawyer, allegedly, and in Minecraft? Because whoever sold that poster and thought, I volunteer as tribute. My name is Katniss Everdeen. I need a little bit, I need them to be okay to stand, for someone else.
The state was able to provide me with some discovery. I think once I filed my notice early Friday morning, I think the state provided a lot of discovery to me. I provided that to Dr. Berklin. I believe he has.
Thank you, Jedi Jess. He was a prosecutor.
The autopsy photo.
And then public defender, his website says he's taken over 100 cases to jury. Possibly. I mean, this is a great case. This is a case that has captured the public imagination. I do think that this case has maybe put into the spotlight that even more, maybe more in real life than the Amber Heard and Johnny Depp case, that men can also be victims of violent, aggressive women. And from the sounds of his psychiatrist and everything, I do feel like they are going to go back to the battered woman syndrome sort of defense. And that really burns my biscuits, because if you look at the domestic violence reports for both of them, they were both antagonistic and laid hands on each other. They were both dumpster fire together. But it's definitely a sleazy way to run this case, but it's your only really trump card that you have. So I get it, but I find it to be gross that she is going to take on a mantle of victimhood and try to, negate every single gross thing that she did to Jorge because of it.
Photographs, which he says are critical. We cannot find the crime scene photographs, which he says are critical to his evaluation. So I know time is of the essence. We've got people working on it, but there is some additional evidence that we need.
State, what's the status of the provision of the autopsy photographs and the crime scene photographs and providing them to counsel?
We provided all of those things previously, obviously, to the defendant, which has been greatly discussed already. When Mr. Owens' notice of appearance came on the case, I instructed my assistant to go ahead and send copies of the document discovery, which is easily available to him, just so that he could quickly have that and not have to worry about getting that from his client or whatever. I believe we also sent notice to as well that if he wants additional copies of the autopsy and crime scene photos or any other pieces of digital evidence in the case, that he just needs to provide USB and he can go ahead.
No. Wait a minute. Because I would like the judge to look dead ass in Sarah's face and say, can we go ahead and say I was right when I wanted to keep all the evidence, out of the jail where you constantly complained that you had no security and no way to control that all of the, evidence was going to stay in your possession? I mean, at some point, if I were the lawyer, I'd be like, oh, you mean like when I told you it could be kept in the courthouse and we could give you a thumb drive so you wouldn't lose the pictures, huh? But I'm too petty, which is why I'm not a judge.
And burn that for him. Again, this is in addition to what's already been provided to the defendant in this case.
Okay, do we have a time frame where we might be able to get that information to him?
But if he wants to come back to my office, we can do it this morning / this afternoon.
Is your office in the building?
Yes, it's in the courthouse.
Right there. Come on, front door, get it out.
I don't have a USB with me, but I'll find one. This morning, we'll get that done.
Okay, I appreciate you both. With regard to the motion for additional discovery filed yesterday,
With
September
before
2,
I
8:30
just
a.m.,
left
state
out.
give the opportunity to review this.
I just reviewed it just now here in court this morning. The state was going to request an opportunity to respond to both this motion and also.
That is just a smugly face, and I don't like any time when let me ask for your district regional manager gets a smugly smile on their face, because again, it is never used for anything other than human suffering. What an absolute, at least her lawyer does seem to understand what is going on, so he is not unprepared. He is filing a flurry of motions, but again, he does understand what is required, and hopefully this case will no longer be the Sarah Boone's shenanigans show. But I don't trust anything that gives Sarah the giggles
Also,
or a
motions,
smile.
statement of particulars formally in writing, given the lack of time we've had to prepare to make a good formal response.
Sure. And how much time, Counselor, would you like in order to file a response to the motion for statement of particulars and the motion for additional discovery?
I would ask for at least a week.
Any objection?
No objection.
Okay, all right. The state shall file a response to both the motion for statement of particulars and motion for additional discovery no later than the close of business 5 p.m. on Tuesday, September the 10th.
Hey, you guys, if you have not subbed to Squid Pro Quo, she does an awesome channel. She is very close to 500, so let's see if we can get her closer to 500 so she can get monetized and get her own little icons. So absolutely, definitely let's get her there. She is awesome and so much fun, so let's do that if we can. Oh, you are so welcome. I am so happy to help other people. It's very odd to be a little to have gotten where I've gotten, and now I have goals and a schedule, but I've kind of just been winging it. So I'm actually trying to be a functional human as I yell at Sarah Boone.
And if hearings are necessary, we'll coordinate those. With regard to the defendant's pro se motion for payment of costs and appointing neuropsychologist to assist the defendant.
Fun Diane, do I need to speak to someone's manager? I don't have, Sarah Boone levels of resting bee face, but I can achieve those when provoked. Who do I need to talk to? I'm gonna need your regional manager and your regional district manager.
In preparation of the defense, the court's going to deny that as moot based on Mr. Owens' representation. With regard to the motion to appoint crime scene reconstructionist and death investigator and motion to appoint forensic psychologist, State, are you intending on filing a response to these?
No, we're going to take no position on those points.
Okay, all right. I will have Ms. Barrios, I'll ask the clerk to see if we can push these through the portal today. So that Ms. Barrios can reach out to JICS and see if we can get a time frame on when they may be able to provide a position statement or a response to those motions, and then we'll coordinate a hearing respectfully.
Judge, I'm going to want to add one other forensic psychologist, make a request.
Good morning, Zach.
I want to make sure that there's not an issue about my client Sarah Boone and I manufacturing the defense. And there's a second doctor, Dr. Michael Ray.
So you're going to be bringing up allegations that you are manufacturing a defense from whole cloth when you are, it sounds like, just bringing back to life the first, and only, sort of plausible defense that this woman has. It doesn't sound like you're manufacturing this from whole cloth until you bring up the fact that you have had allegations that you are manufacturing this from whole cloth. Sometimes don't give those flames any extra oxygen, because now I'm wondering. And I do wonder if the crime reconstructionist, and I would like to see the background of the forensic psychologist that she's working with, because I do wonder if it's going to be a forensic psychologist that believes all men are bad, like we had with Jody, or one that's going to take a fair and balanced sort of approach. I don't know.
All right, sir. Dr. Michael Brandon.
B-R-A-N-N-E-N?
He spells it B-R-A-N-N-O-N. He was the forensic psychologist in the Marsha Thompson case. That was the Palm Beach County first-degree murder where she shot and killed her husband, shot him 9 times. He was laying on the couch and was acquitted of first-degree murder back in July of this year. That was a 2019 case, so that took a while to get to trial. But Dr. Brandon testified that a battered woman's experiences affect her perception of imminent danger. And that's going to be a question in this case, whether or not Sarah Boone, at the time of her actions, was facing imminent danger. In addition,
Okay.
Dr. Brandon.
Again, here is the huge, humongous problem that Sarah is going to have with this battered woman syndrome. She does not portray herself, and as a person who has gone through a not so great marriage, there are behaviors you do when you have been constantly put down in a relationship. You apologize for things. I can tend to turtle in and kind of get very small. I am an, obsessive people pleaser. So there are behaviors that other people that have been through these kind of situations can recognize, but Sarah displays none of them convincingly. And she can't even halfway, act them out convincingly. She doesn't have a meek, mild, subdued, submissive, hyper vigilant, looking for attack, walking on eggshell. She does not have that personality and she doesn't portray it. This is the same problem that mainstream media is running into is you cannot, tell people to ignore their lying eyes and not notice patterns forever and ever and continue it to work with the same, returns. People are going to start noticing patterns. And this woman does not engender feelings of sympathy or understanding. She just doesn't. I am sorry. I am sure they were mutually combative to each other, but she does not come across as a person who's walked in those shoes, as a person who's dealt with this. It's just it will not play. You can have all of the experts come through and say the words, but she is not sympathetic. They should be going for a plea deal. That's my opinion. I am not a lawyer, but it will not fly.
Said victims of repeat violence may fear death in situations others would not. And I've tried to reach out to Mr. Brandon this weekend unsuccessfully.
And it's also really, really gross to take someone else's experiences, someone else's, absolute situations they've survived from, and put that on as a skin suit or as a shield as to why you, again, put someone in a suitcase and let them die. It maybe I'm wrong, I'm not a juror in this case, but to me, it doesn't play right. Her body language, and she is going to go on stand herself. It's just not going to play.
And my intent is to reach out to him. I'm hoping he's going to respond. He claims on his website that he responds within 48 hours. That's the only other witness I'm going to need an appointment for a forensic psychologist. So 2 forensic psychologists, Dr. Julie Harper, Dr. Michael Brandon, and then the crime scene reconstructionist, Dr. Michael Burton. And then in addition, I would like Billy Lane, who's seated in the audience. He is the investigator on the case. Because of the claims that we're making that she's a battered woman, we need evidence to corroborate that. So there's a lot of history between her and Torres involving the apartment complex, which is in Winter Park. That was 4 years ago. The ownership of that apartment complex is.
Now, I will say that if you would like to get maybe a deeper dive into what her and Jorge's behavior was like in that apartment complex, Dreading in his first video on the Sarah Boone case has audio of the business manager or the apartment manager, and she goes on to basically say that they were both mutually combative. They both alleged that the other was the aggressor. So you can maybe say battered person, or you can say they were a dumpster fire together. But I find it very offensive to take on the, DV persona in her case. I just find it utterly offensive and not at all plausible. And she lacks the basic acting skills to even put on humility and subservience and scared and all of these you don't even think about these behaviors when you've been in this sort of relationship. I don't notice that I apologize a lot or that I'm, turtling in until Mr. Mo's like, you don't need to apologize to me for any of that, and it's fine. These are unconscious behaviors that I don't even think about doing because they were ingrained in me. I can't with this chick.
Has changed hands, so it's going to be somewhat problematic trying to get information about who all the tenants were that may have witnessed some of the violence involved in these two, as well as we're trying to get together the 911 calls that Sarah made and others made about the disturbances between that couple. So he's got a lot of work to do as it relates to running down witnesses. In addition, we're trying to get arrest reports of the prior domestic violence arrest of Mr. Torres, as well as the officers involved in their body cams to see if there's any evidence on the body cams that would show injuries to Ms. Boone. So we've got a lot of work to do, but I believe it's necessary for us to prove a viable defense of that.
Roland Arthur with I can believe Sarah was the violent one. She scared George into the suitcase. Why else would he want to go in there? Sarah's hide and seek story makes no sense. No. And that's the thing. It absolutely, I get that this is her defense is really only plausible, sort of strategic action. I get that. But it's just like every woman who makes a Me Too claim that doesn't have any evidence, or the evidence doesn't support her claims, but it's still her truth. So what are we going to do with that? I'm sorry. I don't like it. I don't like it at all. And yeah, Jedi Jess brings up a good point. He's been on this case for like a year. What the hell has he been doing? Jedi Jess was able to get inmate notes and the autopsy report super easy. Heck, even some YouTubers are getting some of their prior body cam footage. I mean, how is it so hard? I am just, ugh.
The battered spouse syndrome, that we have cooperation. It's going to take a little bit, but I do need the appointment of that expert. He tells me he's already on. I'm going to have to file something else because it was under Sarah Boone. Now, as the attorney of record, I'm going to have to file something. He says he's still got plenty of hours to work under that original cap. So I'll be filing something today or tomorrow as it relates to that. But that's the only other. Of course, I've been retained, so I'm not going to make any claims for attorney's fees. I'm not making any claims for travel costs, just for these witnesses.
The JCS has already approved, I believe, $10,000 in investigation fees and $1,000 for other costs associated with Mr. Lane. That was at one of our previous hearings. Now, that was when Ms. Boone was representing herself pro se. I can't imagine JCS may change their position with regard to those costs.
That is also true, Peter A.
File it, and we'll try to tee it up for hearing as well to see if they have any position, or it could just be, the order can be modified to extend to you as counsel for Ms. Boone.
Thank you.
All right. That takes us now then to your motion for continuance file that was filed on August 30th. Court's had the opportunity to review that motion. Any other arguments or statements with regard to that motion? Mr. Roberts.
Judge, I reviewed the state case law relating to continuances and the abuse, palpable abuse of discretion when the court does not grant it. But it is critical to my theory, our theory of defense, battered spouse syndrome. And as you know, that takes time to develop, especially with.
No, we're going to go back because I think the closed captions got your statement correct. Our defense is foul.
It is critical to my theory, our theory of defense, battered spouse syndrome. And as you know, that takes time to develop, especially when the motion basically speaks for itself, but we're in a time crunch. Essentially, the trial is set for October the 7th. I have to provide a notice of intent to rely on battered spouse syndrome 30 days prior, which is September 7th, which falls on a Saturday, so I believe that gives me till the next business day, Monday, September 9th. But still, 6 days for Dr. Julie Harper to come back out and visit with Ms. Boone, coupled with this other potential forensic psychologist, Dr. Michael Brandon. He's not going to have time to do that. They've got to establish a rapport with her before they can run the testing, spend the time with her.
Sir, your client has been unable to establish rapport with all of humanity. I don't know that extra time is going to help her with that.
It involves some some extensive history. Obviously, that couple was together for 3 or 4 years. I still haven't peeled back all the layers. I've tried to go through it, but as you know, something like that is going to involve several instances of domestic violence that did not involve law enforcement, that was just between the two. So we've been going through that. We're trying to get some medical records where she was stabbed by Mr. Torres in the leg, and some other evidence. It's just going to take some time, coupled with the fact that I've got to get Mr. Lane to get all this other objective evidence, witnesses, and 911 calls and arrest reports, and provide that to the 2 forensic psychologists for them to help formulate their opinion as to whether she is, in fact, a better spouse. In good faith, I believe she qualifies based on my spending 3.5 hours with her Labor Day, yesterday, as well as the other 4 times that I've met with her. I have not spoken to Mr. Cordelia, but I believe that was probably going to be where he was going to go. I was not, involved. I don't believe you were involved at that time. Or may have been.
Not me.
Okay.
My predecessor was.
But I think it was always ready to go. And for whatever reason, he withdrew at the last moment. And then here we are. But I think it's prejudicial if we're not allowed to present the defense that we believe we have a viable claim. And I would respectfully ask, I'm not asking for, I think most times you come on a homicide case, you would need at least 6 months. I'm asking for 1 trial cycle, 2 trial cycles sometime at the end of the year or first of next year. I can be ready. I think that will give enough time for our experts to visit with Ms. Boone and formulate their opinions. I'm sure the state's going to want to take a deposition. I think they may have a right to hire their own forensic expert to go out and interview to see if they agree. But that's just going to take a little bit of time, Judge. I'm thinking 2 or 3 months, and we'll be ready to go. I'm not asking for a long continuance. The good thing about it is Mr. Cordelia has done a lot of work, my understanding.
So here's my issue with this. I'm sorry, counselor, but what if you spend a requisite next 6 months with Sarah Boone and decide you want to push her off the long end of a short pier? And then all of your progress as you leave and go to greater pastures, now we have to come up with another person. No. As a parent of toddlers, many toddlers, no. You have made your bed, you are going to lay with it. Actions have consequences. I'm sorry you picked Sarah. You chose to represent Sarah, knowing that absolutely there were these time crunches, there were these issues when you joined the case. You can ask for a continuance, but I think that they absolutely just need to move this case forward. I'm sorry. I know a lot of people are going to say, give him the time, she deserves a fair trial. She has gotten more than her just desserts of every single, the court system has bent over backwards for this woman, providing her attorney after attorney because she wanted them to do unethical things, or she wanted them to, follow her craziness, or she was just a pain in the behind to work with. So no, we do not give you an 11D 12th chance. I'm just done.
He's taken just about all the depositions. I believe they've been transcribed. I haven't gone through all the discovery. She's got the 2
Thank you, Jedi Jess. I'm just on my rage box.
We tried, but we have not made it. My understanding is a lot of the 2-hour interrogation with the sheriff's department has been transcribed. I haven't reviewed that, but we do have a problem with that interrogation. Now, that's why I made the request about the policy. Our policy in my county, Santa Rosa County, is a little bit different. And based on my discussions with her, we feel like I'm going to need to file some motions relating to that. So, because of that, but ultimately because, yes, could I be ready for trial on October 7th? I believe I could, but not without the better spousal things, because I don't believe my experts would be ready. And so that's instrumental in our defense.
State, do you have any position?
I guess the state would just respond to a few things. Part of this battered spouse defense has been previously investigated with several Ms. Boone's previous attorneys, and in fact, the state did retain an expert, Dr. Tanya Warner, who's on the state's witness list in this case. in anticipation of a potential rebuttal of an attempted battered spouse defense. The state's position would be that we would impose a continuance at this time. However, the state's not opposed to setting another status hearing sometime next week, possibly, where we could address this and to see if there has been any movement, anything that would either change the state's position or potentially the court's position as well.
I don't think the state's thinking it through, Judge, because if we wait a week, I've got to file a notice of intent to rely on battered spouse on Monday. We can't wait a week, that the time has expired. If the judge doesn't continue it today.
You knew this going in. I hate people. You know the situation going in, and now you want special, accommodations. Like, well, look, this isn't ideal for me. I am in full no F's given. All my F's are in this little jar for a continuance. So
He wants to have a conference next week, but it's too late for him.
What's your response to the rule requiring these battered spouse or battered wife syndrome defense 30 days prior to
also
trial?
true.
You have to give it.
Right, but I mean, clearly when that rule was created, it contemplated that there would be sufficient time to prepare for that defense within 30 days of trial, which is why they gave 30 days, which is why the Florida Supreme Court said it, 30 days, not 60, not 90, not 120.
But in good faith, you can't file a notice of intent to rely on the defense of battered spouse syndrome if you don't have a supporting psychiatrist, forensic psychiatrist, that makes that claim. I just can't say.
Wait a minute. Sarah Boone's lawyer is worried about ethics and in good faith. Has he heard her intentionally argument?
And I'm putting you on notice. I've got to have some kind of authority. I'm not an expert. I think she meets the criteria, but I'm not a psychiatrist. I'm not a psychologist. I can't make that opinion. I've got to have an opinion from an expert before I can follow that in good faith. I can't do it without Dr. Harper. She needs more time. Dr. Brand needs more time.
All right, thank you. State anything else?
No,
All right, thank you very much. All right, Mr. Ellis, it seems like you've already started diving into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case.
Yes.
I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' basis for withdrawal.
All right,
and why
I'll
the court
allow you to be in
ultimately made a
favor.
decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions.
In all fairness and all snarkiness aside, because I really don't like Sarah, he is being a vigorous zealot and he is arguing for her rights. I really understand that, and I am glad he's being a zealous advocate for her rights. But again, it's that I knew the situation, I knew the parameters, and I knew what I would be getting into for this case. But I'd like to change all those parameters now to suit me. That's what I don't particularly like. You knew you were going to be behind the 8 ball. You knew you were coming in, with very little time to coordinate all of this. You chose the ride and still bought a ticket.
This case has been pending for some time. You advised in your motion to continue that you met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order in the judge portion, that trial specially set for October 7th, 2024, and that would not continue for any reason, absent extraordinarily good cause. And such extraordinarily good cause would not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment, knowing that you were not
Preach
being
it,
appointed,
Judge.
and that by your own representation, you're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court.
He does, John. He really
With regard
does.
to
So I
any of the
appreciate
experts,
it.
there have been multiple prior experts in this case. You already identified Dr. Julie Harper a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020. Under Mr. Padilla's representation of Ms. Boone, at no point in time did Mr. Padilla file a Category A witness list, disclosing Ms. Dr. Harper as a testifying expert, and as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order. Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed with regard to Mr. Heller. Then Winston Hobson had an undisclosed expert that had met with Ms. Boone, as addressed in open court on February 9, 2024. And as Mr. Hobson put it, that expert was not meeting with what Ms. Boone had.
I don't know if he said astutely or stupidly, but
Ms. Boone, as addressed in open court on February 9, 2024. And as Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist that was appointed by Patricia Cashman on February 28, 2024, who had expertise in battered spouse and or battered wife syndrome. There were also Dr. Linda Dore, 2 times sought to be appointed, once by Attorney Bankowitz. Dr. Dore specializes in battered wife or battered spouse syndrome. Once by Dr. Bankowitz Mr. Bankowitz, on July 17, 2023, again by Attorney Hobson on January 1, 2024. Based on the Florida Supreme Court decisions in Middleton versus State, 220 Southern 3rd 1152 and 1176, Barlow v. State 221 Southern 3rd 562 at 569, there's a 2-part test determining the need of experts. We're not going to be addressing that today, as you sought to file these other motions that I haven't had really the opportunity to address. And JCS is not here to have the opportunity to review those. In Roberts versus State, 75 Southern 3rd, 1277, and pinpoint 1281, by the Florida 4th DCA in 2011, citing to Lawson v. State, 884 Southern 2nd, 540, also by the Florida 4th DCA in 2004. In that case, defendant Ramos changed his defense counsel at least 4 times while this case was pending, with the latest change in counsel occurring 2 to 3 months before the actual trial date. There's no record evidence showing that any of Ramos's previous attorneys had provided ineffective assistance.
Jedi, I am really impressed with this judge having these, in order. Now, all of the case numbers sounds a bit like Charlie Brown, want to me, but I'm sure that makes perfect sense to lawyerly people. But I do like that, absolutely, he is paying attention and he is responding to these questions with receipts, with shows of proof that she has had access to these experts. Other attorneys have done the exact same things that he is wanting, and if he could build a scaffolding out of that, and absolutely, Squaw Bob, she lacks the ability to portray herself in any way that anyone could possibly see as not aggressive. She is terminally aggressive and just convinced that she is correct on everything. That type of mentality and that personality and behavior is not really in the Venn diagram of battered wife. Now, that is in the Venn diagram of mutually combative partners who are a pure dumpster fire to be together with. I don't get it.
And the defense had already moved for 4 continuances to prepare for trial. Similar to the Ramos case, Ms. Boone has played a prominent role in shortening the preparation time for trial, as set forth in the court's June 28th order. This case has already been continued 16 times. As of the date of your filing of your notice of appearance on August 30th, this case has been pending for 4 years, 6 months, and 4 days. On June 7th, this case was specifically set for trial on October 7th, and the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role and shortening the time for preparation for trial when her 8th attorney, Ms. Cashman, withdrew. Ms. Boone reached the point where her right to adequate time for preparation of trial was counterbalanced by the right to the effective administration of justice. As of August 30th, when the notice of appearance was filed, there were 37 days until trial commencing in this matter. Considering the prejudice of the denial, Ms. Boone has already availed herself to 4 different attorneys that were not conflicted out, Padilla, Bankwoods, Hobson, and Cashman, and only has herself to blame for the withdrawal of those 4 attorneys based on the representations in those motions and findings in the court's June 28th order. Discovery has been reviewed with Ms. Boone by prior counsels, as established by counsel's representations in various hearings, and prior counsel's motions for attorney's fees, all of which were filed in the month of August of 2024. Ms. Boone has had discovery in her possession since August 5, 2024. The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you are not court appointed, sir, the court's done its own research with regard to your expertise. You've been barred since October 15, 1986, with a duly elected public defender of the First Judicial Circuit in the state of Florida. From 2009 to 2012, you've tried over 100 cases to verdict throughout your career. You've met with Ms. Boone on 4 occasions, as outlined in your motion, not including the meeting that you had with Ms. Boone yesterday. As to the battered spouse syndrome defense, you still have time to file the appropriate notice in accordance with the rule. And considering all the factors as set forth in terms of the state 311, 7th, 3rd, 185, and 10.189, Florida 2nd DCA 2020, your motion for continuance is denied. Matter of this trial is still set for October 7th. We will have pre-trial the 6th to 27th. Pre-trial in this matter, or trial case management will still be set for September 26th at 9 a.m.
Judge, a couple of things. Number one, I have a full practice. I've got a docket day this afternoon in Santa Rosa County for Circuit Judge Scott Duncan. I have 12 clients that are pending. I've got other people covered, but I do have a full docket. If we set some of these hearings involving my motions, could I be allowed to hear by Zoom?
Any objection?
No, Your Honor.
The only request that I would have, sir, is the rules of general practice require a notice regarding your appearance. If you could just file a motion and provide a form order, I'll sign it and you can appear virtually. There's no reason for you to drive all the way.
I will be covering this with Squid Pro Quo, so we'll be trying to work that out to figure out how we're going to cover this. I may take morning streams and she may do afternoon, and I'll pop back up when the kiddos come home, or however we're going to amalgamate it. But yes, I am planning to cover this with Squid Pro Quo and keep all of our shenanigans in-house. Good morning, Jude. So if you are just stepping in, the judge did deny a continuance in this case. He does believe that the lawyer is competent enough and has been practicing law enough that he should be able to figure something out with all of the extensive background and expert work that was done by the previous attorneys.
All the way down from Santa Rosa County for all these hearings, when we can appear virtually. JACS, I imagine, will be appearing virtually for some of these motions with regard to the experts. So as long as you file a notice in advance, sir, I've got no problems with that.
Judge, in that pre-trial order, it mentioned, I thought, that the state attorney was supposed to meet with the defendant and the defendant's investigator and review all the digital evidence from the order. That's the way I read it. They were supposed to sit there all together and watch every potential video exhibit the state was going to intend to introduce at trial. That has not happened.
That's not a problem with me.
I don't mind extending that because I'm going to need to look at the evidence.
With regard to the digital, the deadline, you are correct, sir. The deadline was today, based on the August 5 order. If it did not happen before then, as I outlined at the beginning, there was a change to that process. A thumb drive was provided in open court to Mr. Lang on August 9. He then provided it to Ms. Boone, a thumb drive of the specific digital evidence that the state is seeking to admit at trial, based on the witness and exhibit list that was filed under seal on August 9. Ms. Boone had the opportunity to review that information at that time.
All right, I'm going to ask for more time for me to review the digital exhibits they intend to introduce. I don't know if they've been redacted, I don't know if they're originals, but I'm going to need to look at that. And I went to the jail yesterday, I had let them know in advance that I was coming. I believe my secretary had emailed them and said I wanted to bring in my laptop and my phone to view evidence and whatnot. I was not allowed to bring in my laptop and phone yesterday for 3.5 hours. So I didn't get done a lot of the things that I wanted to get done within that period of time. Probably would have stayed there a lot longer if I would have had that.
It's almost like you volunteered for this position and then didn't look up the protocols at the jail. That seems like a you problem. Again, you came into a dumpster, a nuclear volcano with a dumpster fire on top kind of a case. And you didn't anticipate that there were going to be differences. You picked a case that was completely out of your jurisdiction. Again, these are all personal you problems, sir. I am sorry that the prison didn't, allow you to take your laptop in because Sheriff Cletus from your community. Well, it doesn't work that way. Stop.
Capability. So I would
Welcome,
ask
Megan
for
Fox
some
and
more
Legal
time
Vices
to be
Raiders.
able to
Thank you for
through
joining.
digital evidence as to what they're.
If you are just joining, yes, Sarah Boone is no longer going to be her own third-party intervener. I will be having a glass of wine tonight to cry into my tears for the whole lack of absurdity that we are going to have now. But the judge just told Sarah Boone's new lawyer that he will not be getting a continuance due to his wanting to use battered spouse or battered wife syndrome. Plenty of other of her attorneys have done sort of the groundwork with experts and having that sort of taken care of, that he will be able to, in the judge's opinion, scaffold together this defense within time to keep the trial date in October.
I assume it's being redacted. I know some of the audio in terms of clients, comments my client made, comments the officers made, some of it is, in my opinion, improper to be presented before the jury. So I'd like some extra time to be able to do that.
State.
Your lawyerliness, if you take Detective Candy's and Detective Shiny Shirt's FU monologue out of there, I am going to sue the court because that was the funniest part of the entire interrogation. Well, what does FU mean to you? He's like, well, that's inappropriate. Your client said it, sir.
I'm not certain, is he asking for a continuance again? What is the extra time that he's seeking?
What is it you're asking for? Extra time to do what?
The way I understand the order, I'm looking at paragraph 4 of the scheduling order and notice of hearings that, Judge, you signed August the 5th. Paragraph 4, the state's digital evidence will be reviewed with the state's investigator, the defendant's investigator, no later than September 3rd, 2024. This evidence viewing can be done in advance of September 3rd deadline. The state shall provide the defendant USB drive with station. They never viewed it with my client in its entirety. As the order states, they were to do by today. So the state attorney has failed to comply with the court's order.
This is a good point. If it was not done to the letter of the law, the judge needs to, or the letter of the order, the judge does need to get on the state. Now, I thought that hearing was for the physical evidence, but I don't know. I thought it was for them to go over in court the physical evidence, and we were transferring a thumb drive that was given to the state. But I could be wrong. I didn't read the actual orders. I will have to do that. So
I'm saying I haven't had a chance to view it either. Can we reset that deadline?
Give me a moment. had a different hearing. And at that hearing, we addressed the digital discovery review. Mr. Lang was here. There was a USB provided in open court. And the August 9 order and notice of hearing identifies a change to that August 5 order. Specifically in paragraph 4, prison break investigations by and through investigator Billy Lane shall take possession and custody of the USB jump drive, which contains the state's digital evidence, tendered in open court on August 9, 2024, and shall provide same to Major Malik X. Muhammad at the Orange County Jail today, August 9. Paragraph 6, prison break investigation shall file with the court a notice reflecting that the discovery in the USB jump drive, which contains the state digital evidence, was provided to Major Malik X. Muhammad at the Orange County Jail, including the date and time of the transfer.
Yes, we are still getting the trial in October.
Mr. Lane and filed in the court file. It was discussed at that August 9 hearing as to the revising of the digital evidence schedule. Paragraph 8 states that on August 14th, 2024, 1:30 p.m., a hearing will be held, courtroom 12A, regarding defendant's review of the USB jump drive, which contains the state's digital evidence. The defendant's August 7th letter to the court, provided to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024, the pertinent case law is attached. On August 14th, we had a hearing, we discussed that, and we identified that she had the deadline until August 23rd to make any objections. Now, under the original scheduling order, which said this matters, which on August 5, which set the schedule for when there would be deadlines for objections, those would be extended by good cause shown. Are you seeking at this point in time to extend the deadline for a period for objections which has since expired?
Yes.
Okay, state?
No.
Okay. How much time would you like, sir?
Now, Julie, this is the exact problem that I think anyone on a jury is going to have with her battered woman defense. And again, it is the only defense that you really could logically put on this case. But Sarah does not engender sympathy from most people. She is aggressive, she is assertive, she is abrasive. None of those scream victim to most people. So you can have all the experts come and, plead their theory and show how she was battered. But the minute she takes the stand or we see her interrogation, it is all over because her entire face can't do, subdued, cowed, submissive, anxious, hypervigilant, scared, fearful. She doesn't have that. She cannot convincingly play that, and the way she tells stories does not come out as a victim narrative. It's lovely when you choke yourself with your own saliva. But she doesn't have a soft character, and I don't know how you would soften her appearance, her attitude, her behavior, because as soon as she hears something she does not like in court, she is going to be just like Letitia Stalk and roll her eyes and shake her head or Shanda Vander Ark and make a funny little face like, that's not true. She is not going to be able to pull this off.
In order to review the state's digital evidence that it seeks to admit into evidence and tender any objections.
I've got to go by the jump drive. I've got to take it down to his office. He's going to give me that evidence. Obviously, I need to review it with my client. I've got a flight out of here around, I think, 4 o'clock. I don't know if I can get it done by then, but I don't see the necessity of an issue, maybe a week prior to trial, whatever that is, a week prior to that Monday, October the 7th, the week prior.
State.
I'm a meeting.
Wait a minute, you done made a big thing about how the state might have redacted stuff, might have transposed the images, might have done all sorts of undercover shenanigans with this digital evidence. And now you want to wait till a week before the trial to find out if that was possible, that, they've doctored this in any way, shape, or form. Stay on a consistent trajectory, sir. I need to understand what's going on here.
amenable to setting a status hearing that week.
Here's what we're gonna do. We'll address any objections to any of the discovery when we have trial case management on the 26th.
Thank you, Judge.
All right. Anything else, Attorney Owens?
Give me 1 minute.
Sure.
That's
State, anything else?
not this time, Your Honor.
Madam Clerk is going to work dutifully to, it's already done? Excellent. I'll have Ms. Barrios, my judicial assistant, forward these to JCS and see if we can coordinate a hearing. State will have till close of business September 10th to file responses to motion for statement of particulars and motion for additional discovery. Parties have no other business before the court. You'll have a fabulous day.
Thank you, Judge.
Thanks, sir.
Can I have a word with Sarah?
Absolutely.
Those are famous last words. Who wants a word with Sarah? Not me. So there you have it. Sarah Boone is not getting a continuance, though it does look like, according to her attorney, that we are going to get a battered spouse or DV sort of defense. Now, some of the expert names that I have written down include Julie Harper, Tanya Wagner, and Michael Brandon. So Michael Brandon looks to be an expert that this particular attorney wants to use. Julie Harper was, I believe, retained, or her expertise in battered woman syndrome was asked for by the third attorney that withdrew weeks before the trial. So that was Julie Harper. Billy Lane is her investigator. And then Tanya Warner looks like who the expert that the state might have on tap to refute any of these claims of battered woman syndrome. But I have to look up, because I do want, it seems like the lawyer was implying that Michael Brandon, the expert that he would like to bring on, was instrumental in a Florida case of a woman, I guess, mag dumping into her husband due to a perceived threat assessment of battered spouse syndrome. And thank you, Wolfram, for gifting 5 memberships. And those went to Mamasaurus Rex, Flash Fan 85, Rebecca R, Bam Bam, and Rowdy. So let me get those written down. And thank you so much. Welcome to the Church of Mo. We have dark chocolate and sarcasm. But no plastic recorders. Those audio assault weapons could be left at home and never given to anyone ever again, if possible. If you have been a parent at one of those recitals, you know what I'm talking about. And that looks like what we have of Sarah Boone for today. Now, I will be letting this go. I don't know. We will have to ask Lesko Brandon if he is related to Michael Brandon, because I will be impressed if he is. Trying to get these names written down while also keeping up. Baker makes this look easy, but it is not, at least if you can't multitask, like anything. But that is it. I don't know what I feel about this lawyer. I feel like he is sneakily asking for an extension every time, or a continuance by any other name. But he does seem to have at least an idea of how to file things. So we won't be going with Sarah, I am confused, Boone on this. And I am glad that the judge, stuck to his guns about not letting her change or add another continuance. I liked that he had receipts. I liked that he pointed out all of the previous experts and, foundation that was laid by her previous 8 lawyers. And I think that like everyone else, we would like this trial to go on now, for the love of Cheetos. And for those of you that are new here, so I have my own little holder thing that I stole from Baker, but I take the tags down periodically. So this is 2024's tags with memberships and super chats. And thank you, Baker, for letting me steal your ideas as always. I'm glad that you let me appropriate your ideas, which is awesome and fun. But those are my kind of feelings on this. I am glad that the judge is standing firm because as much as Sarah Boone deserves to have her day in trial, so does George. And hopefully this attorney will be a zealous advocate for Sarah's constitutional rights, but not let her go incredibly crazy with wild accusations and, you know, things like that. Because I really do think that I have done a video about the autopsy report. I think it goes into maybe some more detail to kind of help you guys understand. You're stealing the cross stitch. It's relaxing and it keeps you from snacking. I mean, at least it does while I'm doing it. So there you go. Speaking of cross stitch, tomorrow we will have court and cross stitch. We will be continuing on the Michigan versus Michael Jackson Blanos case. It is a rerun case, and it does involve the murder of Samantha Walls, a prominent, I believe she was the president of the Ben Israel, I believe, synagogue in downtown Detroit. So hopefully we will get through that, but it's definitely an interesting case because the jury decided to only convict the suspect in this murder, home invasion, assault case of lying to the police officers. So it is a very interesting case. If you would like to join tomorrow, I have 6 children, so I'm doing cases a little bit out of order, but definitely. Well, yeah, Baker has a closet Sailor Moon fan as well. So I will be doing that tomorrow. If you like news without the black pill and a little bit of humor, I do Mornings with Mo at 8 a.m. and 7 p.m. on Monday, Tuesday, Thursday night. So we will have a nightly newsy news show tonight. I am going to be pulling articles for that. And it's fun and awesome, and we try to stay away from politics and, the Mesopotamia. So we try to just get weird, awkward, and absurd titles, and that's what I go over. I hope you guys have a lovely day. I am going to go back to battle Mount St. Laundry because with 6 children, we have all the laundry. So I will be putting up afternoon newsy news nuggets, and let's see who we can send you guys over to. I love that I talked myself through the customization, and redirect. I can send you guys to Recovery Attic or Uncivil Law or to Ada K, depending on what we're doing. I think now it looks like Recovery Attic is doing the Sarah Boone as well. That is all I see going on right now. Unless you guys would like to go to the Young Thug trial. I'm going to pick the Young Thug trial since you have probably been Sarah Booned out. I'm going to send you over to Nicholas. You guys can, but be aware that Recovery Attic and it looks like Ada K are doing Sarah Boone as well. But I am sending you off to Nicholas to look at the Woody's final day on the stand. And I know that has nothing to do with Toy Story, but I definitely just my mind pulled up Woody the Cowboy. So I will be sending you guys over there. Have a wonderful day. Be kind to yourself, be kind to others. And oh my gosh, let's get the Sarah show on the road. I am ready to be done with her. Can we just be done with her? Have a wonderful day, guys. Bye.